Agree that this bill, Mr. Speaker, if passed, will allow unfettered access to the court processes and for everyone to see that justice is done on a particular case. I therefore, Mr. Speaker, urge this House to pass this bill with the speed of light.
Some sounded a note of caution.
I believe this is a leg of the Freedom of Information Act, because the theme that surrounds and underpins the freedom of information is the right and the privilege of the citizens to understand and to know and to participate in government. Indeed, this would not have been out of place to have amended the Freedom of Information Bill to accommodate this particular one. But yes, let it stand on its own, that's fine. However, there are some areas that we need to look at that perhaps may touch on the Constitution. One, the issue of national security. It is not all proceedings. There are some proceedings where sensitive issues will come up. And I believe the judge should have a reserve the discretion to hold such proceedings in camera. Two, the Constitution guarantees everybody the right to privacy. There are some issues that may come up in court, perhaps, for instance, divorce cases, where a lot of dirty linen and issues will come out in the open. I believe every citizen has a right to protect his right to privacy. And so this law, or this bill, when it gets to committee, should look at the possibility of actually giving the judge or creating exceptions to areas that touch on the privacy of every individual, national security, and the rest of it.
And yet, some others opposed it.
Media trial will become the order of the day. For instance, a man is accused of an offense. But from the blast of the whistle in the law courts, when cameras are allowed, everybody, the media takes it as if the man is really accused. Of course, it will take time before that burden is taken off him. That's one. Two, he mentioned the issue of national security, which for me, I just want to pause and say that the fact that some countries are doing it does not mean we should do it, because we have our peculiarities as a country, and we're coming from a different background. So for the security of lives or national security, I suggest that the bill should not at least scale to the secondary, because there are issues of national security that could come up in court. And once recorded and it's on air, you can't retract it. You can't withdraw it. And the other case is stigmatization. And of course, right to privacy. In making laws, we should look for laws that can withstand the test of time, that can stand today, tomorrow, and some other time.
The jurisprudence of law that we all know, and the judiciary, is that the judiciary is the most protected, the most secretive, and the most sensitive arm of government, because in our Constitution, they are the only arm of government that has the power to take life. May God forbid the day that an innocent man is convicted of a crime just because of the pressure of the media on the judiciary. The jurisprudence that you and I know, Mr. Speaker, is that the law would not mind setting free 10 guilty men than to convict one innocent person. Mr. Speaker, the risk that we run if we pass this law is that we are subjecting our trial courts. We're not even talking of courts, the Court of Appeal or Supreme Courts, which are courts of records. Trial courts would be subjected to media coverage Mr. Speaker, the implications, and my dear colleagues, the implications are far-reaching because we are exposing this judiciary to trial by the public. We do not have a jury system, Mr. Speaker. That is why our courts are protected.
It was an interesting debate. In rounding up, a few lawmakers appeared to make a case for discussants to consider the bigger picture.
Any man or woman who goes to court and files a divorce case should be ready to go the whole hog of getting his matter dealt with in court, because you are already in the public domain. You are no longer in private. Mr. Speaker, we are all aware when the state applied for secret trial of IPOD leader, the judge refused it. He said, no, it should be tried in the public. Of course, so I don't see any reason why we should be talking about the press covering court proceedings as a matter that is going to affect the privacy of anybody. The court is already sitting in the open, and the essence of this law is to further create transparency in the judiciary.
We are all aware that when cases go to court, as have been reviewed by the recent arrest of judges, that some judges take bribe, and when they take this bribe, they pervert the court of justice. It's not every judge. But if one person is hurt as a result of bribery, he loses his case as a result of bribery, it shows that justice have been badly misplaced. I don't know whose interest will be hurt if cases are covered by the press. I don't know whose interest will be hurt.
The question is that the bill be now read a second time. Those in favor of the motion say aye. Aye. Those against it say nay. The ayes have it. Clerk is invited to read the long title of the bill.
The coverage of the Nigerian Courts Bill has passed the second reading. It has now been referred to the House Committee on Federal Judiciary. The committee will examine the bill more critically, organize public hearings, collate suggestions and amendments, and report back to the House when its work is done.
I love this one. I love this one.